As we use the earth's resources, let us not forget to replenish and renew its vitality. The public prosecutors, the additional public prosecutors, either regular cadre or otherwise, have the responsibility to the court as an officer of the court, though they serve for the state. And in fact, the law and the courts are considering the assistant public prosecutors as independent officers of the court, and they are at liberty to consider the pith and marrow of the case placed before them and to decide the feasibility of continuing the same. That is, as APP has been considered by the Honorable High Court and Supreme Court as an independent officer and allowed them to participate in the selection of judicial appointments, either for recruitment of civil judges or district judges, by considering the services of the prosecutors as independent service. With the above privileges, they also owe the duty towards the court and public, as they are not subordinate neither to the presiding officer nor to the government in the strict sense, while conducting each case and deciding the fate of the same. They act as independent officers. It is also pertinent to note that the work of APP cannot be interfered by any person, including the DOP, regarding conduct of the case, and they are independent as judicial officers while dealing with the matters such as application under Section 321 of Criminal Procedure Code, dispensing with the witnesses, examining witnesses, etc. The APP cannot be expected to act as a mute spectator when the witnesses spills out some words out of their ignorance or ignores some facts which may be relevant to the fact in issue, and the APP has every duty and responsibility to get clarified with the witnesses by posing relevant questions without leading them by leading questions, as held by the Apex Court in the judgment reported in 2004, Volume 4, SCC 158, Zahira Abibullah Sheikh versus State of Gujarat. The foremost duty of APP is that to prepare the witnesses in tune with the prosecution case, and nowadays, when the APP calls a witness to his chambers, it is labeled as tutoring. Even the courts are in aversion with regard to interview by the APP by stating that the APP cannot tutor the witness by calling him to his chambers. It does not mean that when the APP requests the witness to be present to assess and to tune the witnesses in par with the expectation of the requirements of law, cannot be considered either as tutoring or acting as against the accused and his innocence. After all, he is doing the work of mellowing the witnesses in tune with the prosecution case and to speak within the legal parameters, and he can also substantially reduce the precious time of the court by configuring the portion or the evidence to be deposed in the court, segregating the unrelated facts which may not be useful to decide the fact and issue. This view cannot be taken as one of an object of procuring conviction, but only to inculcate the witnesses within the spheres of the legal parameters. The said view was already promulgated by the Honorable Supreme Court in Hukum Singh and another versus State of Rajasthan, reported in 2000, Volume 7, SCC 490, and it was held that the situation in a case where the prosecution cited two categories of witnesses to the occurrence, one consisting of persons closely related to the victim, and the other consisting of witnesses who have no such relation, the public prosecutor's duty to the court may require him to produce witnesses from the latter category, also subject to his discretion to limit to one or two among them. But if the public prosecutor got reliable information that any one among that category would not support the prosecution version, he is free to state in court about the fact and skip that witness being examined as a prosecution witness. It is open to the defense to cite him and examine him as defense witness. The decision in this regard has to be taken by the public prosecutor in a fair manner. He can interview the witness beforehand to enable him to know well in advance the stand which that particular person would be adopting when examined as a witness in court. The APP owe a greater responsibility than other officers of the state, as they are expected to act independently on a case-to-case basis. The APP are afraid of dispensing witnesses when the material witnesses has not supported the case of the prosecution, even when the entire prosecution rests on the ocular testimony of the witnesses. In cases where the material witnesses have performed a somersault, especially in a case of direct evidence, they even refuse to dispense with the forensic expert whose evidence is covered by Section 293 of Criminal Procedure Code. And it is not necessary to examine all the witnesses for a similar fact, and the law do not require numbers, rather quality and witnesses cannot be counted. The APPs can save the precious time of the courts as well as the time by not dumping all the witnesses who may not speak either about the relevant fact or the fact in issue, and they can also do away with the practice of examining all the persons who has a remote role in the investigation. The APP are not in the practice of taking out an exercise of applying to the court under section 294 Criminal Procedure Code by listing out the documents requiring the other side to admit or deny the genuineness of these documents. In case if the other side admits the same, it can be exhibited in evidence without formal examination of any witness, and the prosecution can also be relieved from the responsibility of proving the said document material by venturing into the strict rules of evidence. The Honorable Supreme Court in Nandan Parswan versus State of Bihar and others, reported in 1983, Volume 1 SCC 438, had held that APP has to apply his mind without being influenced by any of the secondary factors, and he or she has to independently assess as to the feasibility of withdrawal, and he cannot act as a post office. The following factors perhaps can be taken into consideration for withdrawal. 1. The evidence which may not be legally sufficient to receive a logical end to the prosecution. 2. The case was instituted to wreak personal vengeance and vendetta. 3. The government has taken as a policy decision to bring peace and harmony among the sections of the society. 4. The case ended in acquittal. The cases in which long pending warrants which was not able to be executed and the offences are summons cases. I wish all of you to work sincerely and to reach to your respective destinations in your professional career to the best of your ability, true to your own true conscience, since there is no substitute to hard work and no shortcut to success. I once again wish all of you a happy Republic Day, and I thank Madam Vyjayanthi Garu for giving me this blessed opportunity. Thank you, one and all.